This is video lecture 7 on John Stuart Mill's On Liberty. And in this particular video lecture, we're going to take what we said about Mill so far and apply it to a couple concrete cases of, of legal restrictions and the kind of ways we would expect the law to interact in everyday lives. We're going to talk about laws dealing with alcohol in particular. We're also going to talk about laws dealing with parenting and see what Mill says about them. Now, excuse me. So the first thing that I want to talk about is what Mill has to say about what we're going to call sin taxes. Now, to be clear, a sin tax is not like an ordinary kind of tax. It is supposed to be a kind of financial penalty associated with consumption of certain goods that were historically regarded as sinful, in particular tobacco and alcohol, maybe some other stuff too, but historically those are the kinds of goods that were levied a sin tax against. You sometimes hear people talking about wanting to add taxes to other kinds of goods and consumptions, like a water bottle tax. I had one student who was very concerned because there was a tax that was being levied, or it was rumored to be levied on like tanning beds, stuff like that. Anyway, these are a little bit different. Okay, though it's sort of sin tax, Mill wants to focus on in particular concerns alcohol, and he's wondering whether or not a state should take measures to render the means of drunkenness more costly. Render the means of drunkenness would be, alcohol, that's what gets you drunk after all, more costly, or add to the difficulty of procuring them by limiting the number of places of sale. So there's actually two different kinds of mechanisms Mill is considering here. One is a kind of obvious financial penalty. If we make something more costly, we hike up the price, presumably by taxing it. But by limiting the number of places of sale is another way of limiting someone's liberty as well, and I think it's probably worth talking about this. So again, I hope it's clear. A tax limits your liberty in the sense that you now have to spend money on something you didn't want to spend it on. You may have to work more to be able to compensate or pay for those taxes. But another way of limiting your liberty with respect to, say, purchasing alcohol concerns limiting the number of places of sale. Let me give you an example. When I was in grad school in Ohio, you may know this about Ohio, you can buy alcohol like at a typical grocery store, but it's a really low proof. It's really watered down booze. I forget exactly what it is, but it's like it can't be more than 39 proof or something like that. It's not that it can't get you drunk, but you're gonna have to drink a lot of it if that was what your goal is. If you wanted the hard stuff, the undiluted, non-watered down booze, there was exactly one place in all of this particular college town in Bowling Green where I used to live that you could go to. It was on the far outskirts of town. It was only open for very limited hours, and the stuff was obviously more expensive. Now, that's a different kind of penalty. That's a different kind of deprivation of your liberty. If there's exactly one place you can go to get the particular good or service that you want, and it's hard to get there, and it's more expensive. I mean, this is a different, it's just harder to do, right? I think this is kind of an interesting to think about in the context of other kind of debates. So, for example, in some of the current debates about abortion, some of the laws and regulations that are being considered do not outright ban abortive services, but they do place remarkable restrictions on who can perform them, in what circumstances they can perform them, but also in what kind of like medical theaters that they can be performed in. So, in a recent Supreme Court decision, the Supreme Court struck down, was it a Louisiana law? I might be getting the state wrong there, that would have effectively left like one operative abortion providing clinic in the entire state, so that if you wanted to seek and procure abortive services, you could do that, but you might have to travel several hundred miles and have just physically very difficult to get there. I think it's worth wondering exactly in what sense you really have the liberty to procure abortive services in that case. Mill seems to be concerned about these things as a deprivation of liberty, so we should talk about them as well. Now, with respect to sin taxes, notice what Mill says. That was weird. Okay. To tax stimulants for the sole purpose of making them more difficult to be attained is a measure differing only in degree from their entire prohibition. Okay? So if the purpose of levying a sin tax is to simply discourage people from buying it, to make it harder to purchase. Mill thinks that's going to be justifiable only if prohibiting this stuff is. And to be sure, he doesn't think that prohibiting alcohol is justifiable. It's a penalty laid on a person for gratifying a particular taste. Does that mean we can't have sin taxes on anything ever? Well, not clearly. Notice what Mill has to say about places of public resort. By public resort, he means places where you can go to buy liquor, places where you can go to buy booze. Either liquor stores on the one hand, but also more realistically, bars, pubs, beer gardens, and that sort of thing. All places of public resort require the restraint of police, and places of this kind peculiarly. Why? Because offenses to society are especially apt to originate there. And that seems right. We know there's a connection between alcohol consumption on the one hand and, say, violence to others on the other. We tend not to see fights break out in the middle of bowling alleys unless people are drinking. Where we tend to find fights that require more policing are at places like Hamilton Street and Tittabawassee, where we actually find bars and places that serve booze. Okay, so one of the things that Mill suggests is that it is fit to confine the power of selling these commodities to persons of known or vouched for respectability of conduct. That means we might have liquor licenses that you need to get your hands on if you're going to open a bar or a pub or something like that, and we don't give them to just anybody. Somebody with the wrong kind of criminal record or a history of certain kinds, say domestic abuse or something like that, we might deny them a liquor license, and for good reason, because we can't trust them to run the business honestly and safely. For that matter, we might have a kind of financial tax, if you will, on getting a liquor license. But the idea is, in those circumstances, that wouldn't really be a sin tax. And the reason it wouldn't be a sin tax is because it's not for the purpose of getting people to drink less. It would be for the purpose of subsidizing, say, police and safety protections in those particular areas. So, if you want to open the business, you can do that, but if your business is correlated with harm to others, then you have to subsidize the cops so that we can minimize that harm to others. But any further restriction, Mill says, is not justifiable. Limiting the number of beer and spirit houses for the express purpose of rendering them more difficult of access is suited only to a state of society in which the laboring classes are avowedly treated as children or savages. So what is Mill saying about sin taxes and alcohol license here? You can tax liquor, and we can attach a financial, if you will, penalty for those who want to open bars or restaurants that serve alcohol, or for that matter, just outright sell this stuff. But those are not sin taxes, so long as the purpose of attaching financial penalties there is to fund say, safety protection. But if the purpose of the tax is to dissuade people from consuming this stuff, that's not justifiable. So think about this in terms of smoking taxes. Cigarettes and tobacco are taxed pretty heavily in the state of Michigan compared to states like Kentucky, for example, where that's a real sweet crop for the state. If the taxes levied on cigarettes are there to, say, fund public health programs and smoking cessation campaigns, or to subsidize the cost that smokers impose on the state by engaging in risky conduct, that would be acceptable to Mill. But if we're taxing cigarettes solely for the purpose of getting people to smoke less, then Mill says we're really just levying a penalty on people for gratifying a taste, and that's not justifiable. This is all consistent, as far as I can tell, with Mill's principle. What we would be doing in the cases of attaching penalties for owning a bar or buying a liquor store as though we're trying to prevent harm to others. That's what the tax is being used to subsidize. But if I'm trying to get you to refrain from engaging in conduct that I regard as sinful, that is not justifiable, according to Mill. More interesting, perhaps, is what Mill has to say about parenting and procreation and marriage on the one hand. Now, this is something we talked about on the discussion board, so I'm going to say a little bit less about it. But Mill seems to think that we would be perfectly justified in having certain kind of laws that would forbid would forbid marriage in certain circumstances. Mill suggests at least two circumstances. In one case in which we might forbid marriage, apparently, is a case in which we undertake the responsibility of causing a human being to exist, in those circumstances in which the child will not have at least the ordinary chances of a desirable existence. Now, exactly what the ordinary chances of a desirable existence are, that's a really interesting question. It's hard to believe that money and wealth doesn't have something to do with it, but don't for a second think that that's the only thing that's relevant for a child to have a desirable existence. It is not child neglect to be poor. We neglect our children, at least in the state of Michigan, when we fail to provide a minimum standard of care. Okay? That can include, say, physical abuse, but also emotional neglect of children. It's not a neglect is not just about money. Usually, it's about behavior. And I say this as someone who works with the juvenile courts in Saginaw County. I have never seen CPS take anybody's kids because they're poor. I have seen CPS take people's kids because the parents are guilty of neglect. So one reason that we might apparently not provide a couple of marriage license is because they cannot provide the ordinary chances of a desirable existence for the child that they may have, or may not have for that matter. The other circumstance in which Mill recognized would seem to be cases relevant to overpopulation. Keep in mind that Mill is writing in 19th century England. The Irish potato famine is not that far down the road. There were real concerns about Ireland in particular being overpopulated, there not being enough food for the people. In circumstances in which a country is overpeopled or threatened with being so, then produce children beyond a small number is a serious offense to all. Me having kids in circumstances where there's already not enough food to feed everyone apparently harms you. In addition to whatever harm may accrue to the child, it would harm you as well. In these circumstances, Mill suggests that laws which would forbid marriage unless parties can show they have the means of supporting a family are not objectionable as violations of liberty. What Mill's suggestion here is denying you a marriage license does not offend the harm principle. Why? Because I'm preventing you from harming others, either the child that you cannot provide a desirable existence for, or the other people who may suffer because now there's one more mouth to feed. Now, there's a lot to wonder about here, most notably exactly why Mill is drawing a connection between a marriage license on the one hand and procreation on the other. I think we all know that there's not a necessary connection between those two things. Not everyone who's married has kids, and not everyone whose kids gets married. So why Mill is talking about marriage licenses here rather than procreation licenses is a bit of an odd question, but maybe then we just need to reformulate the question and talk about, well, procreation licenses. Now, this is something we've done a bit on the discussion board. I think it's worth pursuing further. But to be sure, Mill thinks that everything that he said about forbidding marriage in some circumstances is permissible given what he says about the harm principle and what we've been calling Mill's principle. Your conduct, where you marry and or procreate, may have consequences for other people. If so, then the state has the authority to intervene and perhaps limit your liberty.